Hi, my name's Griffin Bridgers. Today we're going to look at Revenue Ruling 81-15, which is the penultimate ruling in a series of changes, cases, rulings, and confusion around the effects of control premiums and voting rights when it comes to transfers of non-voting stock. Now, before we get started, I want to remind you that this presentation is not intended to substitute for legal or tax advice and is provided for educational purposes only. So, a little bit of background. This ruling that I'm going to talk about here has been largely superseded, but with one exception we'll cite at the end. But it used to be that there was a revenue ruling, 67-54, which analyzed a situation where there was a gift of 990 voting shares by a father to a children's trust, and then the father retained 10 of the voting shares. Later, when the father died, the IRS came in and said that the non-voting stock that had previously been gifted was includable in the father's gross estate under Code Section 2036. Why? Because the father, in this case, by having the voting shares, had retained the power to remove and replace the board of directors, which would allow the father to control corporate dividend policy. So in other words, even though these non-voting shares had been transferred to the children in trust, the father had retained the right to control the flow of income to the children's trust through those shares, either through the retention of voting stock or the right to become trustee, or both. However, the core argument here and the core focus was simply the retention of voting rights through those voting shares, and whether those voting rights could be extended to shares that had already been transferred. And after this ruling came out, 5 years later, the U.S. Supreme Court held that in this situation where shares have been gifted away, that a director and technically a voting or majority shareholder each have fiduciary duties to the non-voting shareholders and to the business itself, which would prevent, in this case, the decedent from being deemed to have control over corporate dividend policy. So in this narrow set of circumstances, there was no retention of voting rights. Now, in response, Congress went a little bit of a different way to codify this and enacted Code Section 2036b1, which essentially includes closely held corporate stock in the decedent's gross estate if, at the time of death, the decedent has retained the right to vote the stock directly or indirectly, and, in conjunction with that, the corporation is controlled by the decedent alone or in conjunction with other people by virtue of holding 20% or more of the voting power. So you have to check both those boxes, and I want you to note our general 2036 requirement before we get into this, where 2036 looks at property that was transferred by a decedent during life so that the decedent no longer owns that property at death. However, it looks to rights that were retained by the decedent after that transfer over the transferred property. So, in this vein, this is an extension of the 2036A1 power, which allows the retained possession, I should say, or enjoyment of transferred property to be a trigger for including that property in the gross estate. So, the term transferred property is somewhat of a loaded term. In a lot of the partnership cases we look at, really that looks to property that was put into the partnership in exchange for equity. However, in this line of thinking, we're not looking to the exchange of assets for equity. Instead, we're looking to the transfer of stock itself and analyzing whether the decedent has retained the right to vote that corporate stock. So, in that vein, you have to keep in mind that, for one, you avoid 2036 if there is a bona fide sale. And the question of whether there's a bona fide sale is a pretty loaded one that we're not going to talk about here. But there's also a couple threads that the IRS can pull on here. One, this looks to the indirect right to vote the stock, which can be pretty open-ended. It also looks to the right alone or in conjunction with other people to vote stock, which can be pretty open-ended. And while not in the text of the code section itself, but in the regulations, there's an acknowledgement that in a situation where the decedent can have an express or implied agreement to later reacquire voting rights, that may also be enough to trigger this through the thread of 2036A1. So this really looks at stock that is transferred by the decedent during life and analyzes whether the decedent has retained voting rights over that stock. But our original ruling dealt with non-voting stock being transferred. So in that case, are we in danger of violating 2036B1? There's this tension there between Byrum and this prior revenue ruling in 2036 in this vein. How do we analyze the decedent's retained voting stock? In other words, by simply having voting stock, does that mean that the decedent can now have this deemed right to affect the non-voting stock that was transferred during life? And the answer is no. What 2036B1 did is it analyzed a situation where voting stock really had been transferred during life, but in a way where the decedent had, directly or indirectly, by express or implied understanding, retained that right to vote 20% or more of that transferred stock. And that may be that I want to clarify that that's not 20% of the transferred stock. That's 20% of the total stock post-transfer. So the big issue here where you transfer voting stock or where you transfer non-voting stock but retain voting stock is that Byrum ultimately supersedes to say that by virtue of holding that voting stock, you have a fiduciary duty now to the non-voting shareholders, which will supersede Code Section 2036 in general. So beyond this, there's some other rules we have to get into, one being the attribution rules under Code Section 318. Now, while that's an income tax rule, I wouldn't put it past the IRS to at some point in the future look at that from the perspective of whether there is a direct or indirect retention of voting rights. So that's a topic we're not going to look at for the time being. But for the most part, Revenue Ruling 8115 has made it safe to transfer non-voting stock while retaining voting stock without an attribution of powers or rights under the non-voting stock back to the decedent. So beyond this, there's a couple catches, like there always are, that we have to look at. So for one, we have to look at the effects post-gift of what the decedent might have in terms of retained powers. This is where we can pull on that thread of indirect voting rights. So for example, post-transfer, how much power might the decedent have to convert non-voting shares back to voting shares post-gift? If that could be done, then that could potentially trigger 2036B1 here. And in that vein, do fiduciary duties supersede that power? Because that's a fact pattern a little bit outside of the scope of Byrum. Also, we have to look at if it's a transfer in trust as opposed to outright to individuals. We have to go back to the general 2036 and general power of appointment analysis, where we have to check whether the decedent might have the power to remove the trustee and replace the trustee either with the decedent themselves or with someone related or subordinate as kind of a backdoor way to later indirectly reacquire voting stock. And if so, that could be enough to trigger both 2036A and 2036B as well. Now, beyond this, we have to keep in mind that if non-voting shares are included in the gross estate, that is the transferred property here. We don't have to look through the corporation to look at property that was put in exchange for equity, unlike the partnership cases. But in this case, both revenue rulings, the old 67-54 and the superseding ruling 81-15, both acknowledge that there is the potential for a voting premium to attach to those non-voting shares under Code Section 2031 if, indeed, those previously transferred shares get pulled back into the gross estate under Code Section 2036. Now, that could create a step up in basis and additional income tax planning opportunities, but you have to assess the benefit of that against the estate tax cost, and also keep in mind that a step up in basis for corporate stock isn't going to have as much value as a step up in basis for pass-through forms of entities, typically partnerships. So, what are our key takeaways here? How can we kind of weigh these rulings in 2036B and Byrum together? Well, for one, I think it's always important to not take the technical letter of 2036B for granted, because as the IRS has shown in the partnership cases, which I'll mention below, there are all sorts of strings on which the IRS can pull to claim that there have been retained voting rights under Code Section 2036. I cited a few, like power to remove and replace trustee, and even possibly power to convert non-voting shares back to voting post-transfer. So you really have to dig into not just the trust documents, but also the corporate documents to see what powers might be retained after the fact, keeping in mind, too, that from a gift tax perspective, you have to also weigh non-voting and voting under Code Section 2701 to determine the gift tax value of those non-voting shares. So the big lesson here is just because it's a corporation, it doesn't mean that we're safe or get benefits beyond what a partnership or LLC might give from a gift or estate tax perspective. You still have to do that analysis, just now with an acknowledgement that 2036B is really an extension of 2036A1 and A2, which look at retained possession or enjoyment of property, or the power alone or in conjunction with somebody else to affect the beneficial enjoyment of that property or the income from it. And another thing is to keep in mind that while voting rights really only extend to incorporated entities, in other words, corporations at the state law level, and while this doesn't extend to partnerships and LLCs in terms of voting rights, you also have to look at the fact that the same fiduciary duty analysis may not carry the same weight or have as many teeth when it comes to those other forms of entities like partnerships or LLCs. We especially saw that come into play for what is called, quote-unquote, a family investment vehicle under Strange and Powell. So going back to our original analysis under Revenue Ruling 67-54, where we had complete 100% family ownership of the entity, you also have to dig through and look at what are the non-tax purposes of that entity. Is it operating a business, or is it being held for investment? And if it's the latter, then you run into a greater zone of danger when you analyze these rights overall. As always, if you're a tax or estate planning practitioner and you have questions or topic suggestions, you can email those to me at griffin.bridgers@gmail.com with the caveat that I cannot give tax or legal advice in response to your questions. And if you enjoy my content and you'd like to have me as a speaker at your upcoming event, feel free to reach out as well. But I thank you for listening to this video, and I look forward to seeing you in my future content.